excited to think there are ways we can position ourselves for something beyond just survival these days. So Bridget talked about finding liquidity and tax relief, and I touched on a few of the stimulus provisions as part of the CARES Act. The stimulus is over $2 trillion and is expected to grow soon. For perspective, I want you to think about $1 trillion this way. Start with 1 million, make it seconds. 1 million seconds is equal to about 11 and a half years. Take that to 1 billion. Those 11 and a half years now turn into just under 32. And when we make it $1 trillion, it's not just 32 years, but it's 32,000 years. It's a lot of money. Here's the catch. For the payroll protection provision loan that I talked about to be ultimately forgiven or forgivable, we need to keep our staff. And wow, what challenges that brings, especially now. I think it's time to have Renee Noy from WorkWise Law chime in. Renee is a founding partner and co-owner of WorkWise Law, a law firm that exclusively represents employers, getting them into compliance with state and federal employment laws. Having worked for over a decade on the employee side, Renee has insight into what makes a good plaintiff an employment case, and she works tirelessly to ensure that her clients can avoid costly litigation. Currently, Renee misses the days of worrying about misclassifying workers as independent contractors or sexual harassment claims and has been almost solely focused on helping her clients stay afloat through this extremely challenging global pandemic. Renee, what is the best thing to do with my employees right now? Do I lay them off? Do I furlough them? Do I keep them?
So I've been getting that question a lot. All these companies are scrambling, trying to figure out what to do with their employees right now. If you're a non-essential business and you're not able to keep your employees working, then the best thing to do is do a temporary layoff, which is confusing a lot of people, just the language of it. It's an effective termination. When you do a temporary layoff, you still have to provide final paychecks with all of your accrued vacation time. And you're giving them a letter saying that this is a layoff. I'm telling my clients not to promise future employment because we have no idea what the future holds. We don't know how long this is going to last. And your economics of your company may drastically change, and you don't know if you're going to be able to bring everybody back. Obviously, this paycheck protection program it's trying to incentivize employers to bring everybody back, but that's not always a reality. So what I've been advising is to just do the layoff. If you're able to do like the furlough language, it's very similar in terms of just it's a reduction in hours, but the effect is the same. You can still put people on unemployment. Part of the stimulus package, it's giving $600 additional to the state unemployment per week, which is pretty substantial. I mean, there's certain employees in my clients' companies that are now going to be making more on unemployment, and that's been a big issue. Because if companies want their employees to be able to work some hours, but just not full hours, that's been a question that keeps coming up. And the answer is you can still have an employee on unemployment, and you can bring them back to work a few hours a week or however much you need to get your needs met in terms of work and whatever is able to get done, either from home or if you're essential to be able to go into the office. So it's a lot of just language questions, and the laws are changing every single day. It's been really incredibly difficult to keep track of everything. And I give advice, and the next day I'm calling clients back and saying, well, actually, it's changed now. But the best thing, if you don't have active employees, if you don't need them, I would say don't have them, and just have that peace of mind to know that you don't have to be worrying about all these employment issues during this time. And then hopefully when we come back to work within a month or 2 months or however long it could be, you could bring all those employees back and you want to re-onboard a lot of them if possible. The other thing I want to mention is that there's been a few of my clients that have been excited about this and saying, this is my opportunity to clean house. And all these employees I've been wanting to terminate and I haven't been able to because of their protections, now I can get rid of them. And I just want to caution people that that's not exactly the way it works, that you can actually be running into a lot of discrimination lawsuits if you do that. So you don't want to, lay off 20 employees and bring back the 10 youngest or, the 10, the ones that don't fit into a protected class and let everybody else go, because you'll just be facing a lot of lawsuits later on.
Well, so much for that strategy. So let's just say now that someone out there is facing a situation where they have laid everybody off, but then needs employees to come back, or some employees to come back to work for a few hours, a week. Is that going to be a problem?
No, so you can lay them off. I'm getting that question a lot too. So you can lay employees off, and then all of a sudden, some revenue generating project comes in, and you're so excited, and you're like, oh no, I have no employees to do this project. So what you can do is you can call whoever you want to do that work, and then it's up to them to let the EDD know that they're now making some wages, and that's not on you, that's on the employee, to say, okay, well, I actually worked 10 hours, and then they'll reduce the unemployment proportionate to however much you made in wages.
All right, well, that's good news. Well, what about those pesky independent contractors? What do you do if they want to file for
So
unemployment?
that's a really big problem because EB5 was our big issue up until what 3 weeks ago, 2 weeks ago, and independent contractors cannot file for unemployment typically. Now with the new stimulus package, they expanded unemployment rights to independent contractors, which is pretty incredible. But what's happening is most likely in California, at least if you have an independent contractor, you probably have them misclassified and they probably should have been an employee. And the EDD prior to this and currently has the ability to redesignate a worker as an employee for purposes of unemployment. My fear is, but there's nothing you can do. You can't tell a company, don't go have them file for unemployment. They have a right to do so, and you can't get in the way of that. But my fear is that you're going to get on the EDD's radar, and then all of a sudden they're going to come back to audit you, and then you're going to have different problems, but you'll still have problems. But there's really not much you can do at this point. They're allowed to get unemployment. They were probably allowed to get it before because they probably were an employee and you just were calling them an independent contractor. What I'm hoping, what I'm telling my clients is possible, and this is not legal advice because I don't know, but I'm assuming the EDD is so overloaded with unemployment claims, they're not going to have a lot of time to do audits. So that's kind of trying to give some hope to my clients.
There's always hope there's always a silver lining, right? So you mentioned I can't be discriminatory and not bring back that group of people that I didn't want to bring back. But what happens when things go back to normal and I'm ready to resume operations? Do I have to bring everybody back, and how do I navigate that?
No, so you don't have to bring everybody back. If all of a sudden, I mean, hopefully everything will resume back to normal and you'll have the same amount of revenue coming in and nothing will change. That's the hope. But, if things are just a slow go and you really don't have a need to bring back your 20 employees, you really only have a need to bring back 10 employees, then that's exactly what you should do. But like I said, just don't be very careful of who you select because you don't want to just start figuring out, all the protected classes and just, only hire the ones that don't fit into that. But what you do want to be careful of is of all of a sudden if you're calling this a temporary layoff and then you bring back 10 employees and then 2 months later you're like, oh wow, now I actually need 5 more employees to come back. Well, if you start hiring outside of that pool of your employees, then if you replace it's all about protected classes. So if you replace one employee that's 60 with an employee who's 30, that could be a problem if that employee, the original employee, finds out about it. So you just want to be very, very careful and look at who you're bringing in. Try to bring back, especially with the payroll protection. That's the whole point of that is to bring back the same employees. And if you bring back fewer employees or you change out your employees, if it's a different head count, then you're going to end up having a reduction in the loan forgiveness. So that's also something to be aware of.
Awesome, Renee. Thank you. Renee always seems to make employment law fun. Not sure how, but your enthusiasm is always appreciated. So.